Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors, and I want to welcome you all to our Legal Hot Topics webinar, The Latest in Fair Housing. Today, we have with us our Legal Dream Team, Director of Legal Affairs, Kathleen Dartez, along with our Associate Counsel, Taylor Kitzmiller and Diamond Smith. Together, they will dive into frequent legal hotline questions, a potential new protected class for the state of Maryland, and industry trends such as appraisal bias and AI in fair housing. This webinar will be recorded and sent out to all attendees after the conclusion of the webinar. We do encourage your questions and we look forward to answering them. Please post all your Q&As in the box below at the bottom of your Zoom screen. And with that, I will turn it over to Taylor. Taylor, take it away.
Thanks, Kelly. All right, get this PowerPoint pulled up. Okay, great. Yep, I hope everybody is here for fair housing to learn about some existing issues that we're seeing, some new protected class, which I'll dive into right away, that will be implemented into Maryland law come October if it is signed into law by Governor Westmore. Excuse me. Diamond, you can go ahead to the first slide. Okay. So the new protected class that was contained in House Bill 598 that was passed in this legislative session. The new protected class is military status. Before the passage of this law, I hope you all know that in Maryland, Maryland law prohibited housing discrimination, based on the following protected classes: so race, sex, color, religion, national origin, marital status, familial status, sexual orientation, gender identity, and then the most recent source of income, which Diamond will be touching on later in this presentation. Now, if this bill is signed into law by Governor Westmore, starting in October of this year, military status will be added to that list of protected classes. So what does military status actually mean? Military status is someone who is an active member of the armed forces, a member of a reserve component of the armed forces of the United States. So Army Reserve, Navy Reserve, Coast Guard Reserve, National Guard Reserve, etc. Or also a dependent of an active member of the armed forces, such as their spouse or child, also counts as somebody under military status that falls under this protected class. All right, Diamond, you can go to the next slide.
This is your next.
I think go back one more, maybe. Nope. Yeah, that was right. My bad. Okay, so how does this affect your practice in real estate? So licensees and their clients may not discriminate against a person if they are considered a protected class in the state of Maryland. And now, if military status is passed into law come October, you will also not be allowed to discriminate against somebody due to their military status in the home buying or renting process. Whether you're representing a seller, a buyer, renter, you cannot discriminate against somebody due to their military status. So there's a list here. This list is not an exhaustive list. It's just a couple of examples of what you cannot do here. So refusing to sell or rent a dwelling after the making of a bona fide offer, refusing to negotiate for the sale or rental of a dwelling, making a dwelling otherwise unavailable to somebody in a protected class. We're focusing on military status here. Discriminating in the terms, conditions, or privileges of the sale or rental of a dwelling, and making a statement with respect to the sale or rental of a dwelling that indicates a preference, limitation, or discrimination based on military status. So basically making a remark saying, we prefer other applicants outside of people who are in the active military. All right, Diamond, you can go to the next slide. Here's some examples of what not to do. And again, this is not an exhaustive list. This is just a couple of examples I thought of that immediately popped into my head when I learned of this new law. So first, stating that military members are not welcome to apply to purchase or lease a property, charging higher rent for a military member compared to another applicant, charging a higher security deposit for somebody in the military compared to other applicants, telling a military member that a property is not available when that property actually is available. I foresee, and I could be wrong, but I foresee the most complaints surrounding somebody in the military being discriminated against will likely come in landlord-tenant disputes, where tenants who are in the military have certain protections because they are in the military. One of those protections is they can terminate their lease early if they get military orders that cause them to, have to move to another state, for example. And I can see landlords, if they know of that ability for somebody in the military to terminate the lease early, maybe they wouldn't want to lease to somebody in the military because of that, exemption, that rule. But since military status is now, or is going to be, a protected class in the state of Maryland, and your landlord says, oh, well, I don't want to rent to somebody in the military because they could just leave town and get out of the lease early without penalty. That's a great example of when you would have to sit down with your client and say, no, they are a protected class in the state of Maryland. And that's this in bold at the bottom here, the takeaway. You have to provide equal service and treatment to members of the military. If your client wants to discriminate against somebody because of their military status, you should inform them that doing so is going to, 1, violate Maryland law, and 2, it's going to violate your code of ethics, and it's going to put your license in jeopardy. And I hope everybody agrees that putting your license in jeopardy for one client is not worth it. So yeah, that's just keep that on your radar. We're expecting it to be signed into law by the governor. So again, come October 1st of this year, that is going to be, military status will be a new protected class in the state of Maryland.
Taylor, I just have a random comment. I think everybody knows that our governor served in the military. So if you're a betting person, you can't predict what's going to happen. But if I were a betting person, I would think the chances are pretty good that he's going to sign that into law.
Right. Thanks, Kathleen. Okay, transitioning away from that, going to discuss assistance animals. I believe we discussed this at our last fair housing webinar, but it continues to be a topic that we get a bunch of questions on the legal hotline about. So we'll dive into that here. So assistance animals, they're broken down into 2 different categories. First, you have a service animal. Service animal is individually trained to do work, perform a task for the benefit of somebody with their disability. One thing to note about a service animal, by definition, it must be a dog. The second category is a support animal. Now, unlike a service animal, support animals can be any companion animal of any species. So it could be your pet parakeet, your cat, your turtle, whatever it is, as long as that animal provides a therapeutic benefit, which alleviates or mitigates issues that are caused by somebody's disability, they're going to be considered a support animal. The third bullet point there, and I'll expand on this a little more in the next couple of slides, but the applicant, let's say if it's a landlord-tenant situation, the tenant wants to have an assistance animal, the applicant may be asked to provide documentation, including a note from a physician, psychiatrist, social worker, etc., so that the landlord or a condo HOA can properly review the request to have the assistance animal. Or we can go to the next slide, Diamond. Okay, so these next few slides take you step by step of how a landlord or a property owner should process a request of a tenant or a buyer to have an assistance animal in the property. Now, this step-by-step process was taken directly from guidance from HUD. They issued, at some point last year, they issued 4 or 5 page document kind of explaining assistance animals, how they're supposed to be, how their requests are supposed to be processed. So we broke that down here into a step-by-step explanation. So first, What is a request? There are no requirements regarding the form or the timing that a request has to be made in. In other words, let's say I'm a tenant and I want to have an assistance animal. I can make that request in any form. It could be through email, a letter, phone call. It does not have to be on some standardized document. The second bullet point there, HUD's guidance states that a landlord should respond to a request within 10 days of receiving the supporting documentation that goes along with the request. Again, that's not, by law, by statute, they must respond within 10 days. It's just the guidance of HUD. Also, landlords have the option to provide their own assistance animal request forms. They can make their own standardized document and provide it to the tenant, but the tenant does not have to use that form if they don't want to. Kind of goes back to that first bullet point. They can submit that request in any form. Okay, number 2. So in this step in the process, the tenant we're going to just focus on landlord-tenant example here. Tenant has officially made their request. Number 2, does the tenant have a disability? So disabilities are mental or physical impairments that are going to substantially limit one or more major life activities of somebody with that disability. To qualify for a disability accommodation, which having an assistance animal counts as a disability accommodation, that person must either actually have a disability, be perceived as having such a disability, even if that perception is wrong, such as where a landlord rejects an applicant based on the mistaken belief that that applicant has HIV. That's an example of an old case from, I believe it was in the 80s or the 90s. And finally, or that person has a record of having such an impairment. So for an example here, a recovered drug addict, even though they may not be currently a drug addict, a recovered drug addict still counts as a person with a disability.
Quick question, Taylor, or Kathleen. We have a couple of questions in the chat. Do we want to wait till the end to answer those?
Yeah.
Yeah, I think we probably should, just to make sure we get through our content first.
Right. Yeah, we'll circle back for the questions. Okay. Number 3, does the animal qualify as an assistance animal? I already touched on this previously. You have 2 categories: the service animal, a dog specifically trained to perform a task for the person, or a support animal, which is any species of animal that alleviates some aspect of the disability, no special training required. That second bullet point under service animal, if the need for a service animal, and honestly, I should change this slide and it counts as a service animal or a support animal. If the need for that animal is not readily apparent, for example, somebody with a seeing eye dog, that is readily apparent that they need that dog to assist them with, moving around. If it is not readily apparent and you can't see the disability, for example, somebody might have anxiety, which is considered a disability, the landlord may ask whether the animal is required because of a disability. And if it's a service animal, what specific, how has that animal been trained to assist that person? Okay, moving on to number 4. Did the requestor, so in our example, the tenant, provide appropriate documentation to support their request? The landlord can only request verification of the disability, again, when the disability is not observable. So if we're going on that example of somebody with anxiety, you can't see the anxiety. In that case, the landlord can request verification that the person does have a disability. And how do they go about doing that? So verification can be in multiple forms. It can be in the form of a notice from a government agency, receipt of disability benefits for that person, eligibility for housing assistance, or information confirming the disability from a healthcare provider. Really, anything that that person can use as proof, saying, look, here's documentation that, yes, I do have a disability. For example, I provide you with a receipt that I get disability benefits. That's proof that I have a disability. What can a landlord not do? A landlord cannot ask about the specific details of the disability require a tenant to undergo a medical examination, or require a medical professional to use specific forms, provide notarized documents, or make statements under penalty of perjury. Okay, so at this point, the tenant has made the request. They've provided you with documentation, let's say from their healthcare provider, proving that they do have a disability. Now we're up to this point, number 5. Is the requested animal accommodation reasonable? The request is going to be reasonable if it does not cause the landlord to incur undue financial and administrative burden, doesn't cause a basic or fundamental change in the nature of the housing program that is available, will not cause harm or damage to others, and is technologically impossible. So that third bullet is bolded there because typically if a request is considered unreasonable, that's the reason why. Because introducing that animal into condo, apartment could cause harm or damage to others. An example that could be it might be a silly example, but it could happen. Oh, we might have lost Kathleen. Oh, she's back. Is if somebody were to request to have their assistance animal that is a crocodile that helps them with their anxiety, introducing a crocodile into an apartment complex could clearly cause harm or damage to others. That's an extreme example, but just to make the point there. And finally, number 6, are there any alternatives to accommodations that are unreasonable? So if the landlord determines that this is an unreasonable request, that landlord should try to determine if there's any alternative accommodation that can be made to help that tenant with their disability related needs. And one other just note here before I switch it over, I believe, to Diamond. People think service animals or assistance animals, once they're approved, you can't get them out of the condo or the apartment. That's not true. If that animal causes issues, that you could ask that person to either remove the animal or just vacate the property if they refuse to remove the animal. One example of that was a case down in Florida a few years ago. It was tenants. They had two service dogs approved to live in the property. They lived there for a year or so, perfectly fine dogs. Developed a barking habit in the middle of the night, kept up the neighbors. The neighbors complained to the apartment complex. Apartment complex said, you need to remove the dogs or you can move out, one or the other. Of course, it went to court, and the court determined that no, that was a reasonable move by the apartment complex because the neighbors have the right to use and enjoy their property just as that person with the service animal does. And by the dogs barking, that took away the neighbor's right to use and enjoy their property, and that the dogs could be required to be removed. So that's, just an example there. All right, that's all I have for assistance animals.
So moving into just housing data. So looking at the National Fair Housing Alliance, this is available on their website, but you can see the types of complaints that have been compiled as of 2022. So this was in their 23 trend report. As Taylor was saying, speaking on with disability, that happens to make up 53% of the complaints that have come in. And then I'll be speaking a little bit later as to what this other total is. And this other comes from rentals. It comes from source of income discrimination, sex discrimination, gender discrimination. So there's a lot of different components that make up this other category. And we'll delve into that too in a little bit. But yeah, as you can see, National Fair Housing Alliance did a database, and we see that race accounted for 3,344 of those complaints. Disability was 12,464. And as you can see too, with the other departments or government agencies, so HUD, the Fair Housing Private Agencies, Department of Justice, as they compiled the list, the overwhelming amount here was 17,580 in disability complaints. And then moving into the chart, fleshing out a bit of what that other was talking about, breaking down the types of transactions that have come in as the main complaint, and overwhelmingly 82% of those complaints have stemmed from rentals. And a great significant portion has been dedicated to source of income discrimination, which is this 27,336 number, which is an uptick from the year prior. And I'll get into the details of what source of income is, what source of income discrimination is, and then also what it is not, so that it's more clear. Because of that uptick, I think there were about 1,800 more cases in the year prior that caused this uptick as well. But we'll get into that discussion of including the main case that spurred the reactions for the other complaints. But yeah, this is the total that, as you can see, 27,336, and then the percentage of 82% of those complaints being with rentals. Moving it to Kathleen.
All right, thank you, Diamond. Appraisal bias, this is going to be kind of an overview. I think everybody's hopefully familiar, or at least somewhat familiar with the case. There was a very high profile case here in Maryland. It was a property in Baltimore City. The lawsuit was filed a couple years ago. What it was a couple owned a home in Homeland, if you guys are familiar with Baltimore City. It was a couple, they both were professors at Johns Hopkins University. It was Dr. Conley and Dr. Mott. And they had purchased their home, I think it was $450,000. They had improved their home, made some improvements, and then they wanted to get to refinance their mortgage so they could, continue to make some improvements to their home. And they applied, I think they spoke with their loan officer. Yeah, I don't have any, I'm just talking. I didn't put any bullet points. It's kind of an overview. So yeah, they spoke with their loan officer, and their loan officer said, oh, you shouldn't have any trouble getting at least 550, 560, no worries at all. The appraisal was conducted, and the appraised value of the property came back. It was $472,000. Which they were shocked by, honestly. Their loan officer told them significantly higher. I think, they had neighbors who'd refied and had, their appraised value was significantly higher. They were shocked, and I think, fortunately for them, I guess they both, like I said, they both were professors at Johns Hopkins University, both professionals, and I believe the husband was a history professor, obviously well-versed in civil rights and civil rights law and the history of civil rights issues and discrimination in the U.S. So what they decided to do is this is unfortunate that there is a phrase for this. It's so common that there's a phrase for it, but it's called whitewashing. They whitewashed their home, meaning that they took down family photos or any sort of cultural artwork. I think they removed hair care products from the bathroom, whatever it was, anything that would indicate that the home was occupied by Black people. They removed all of that, and they had a colleague come and sit at the house for the second appraisal, right? And the colleague, I think, brought some of their family photos or brought some, sort of generic looking artwork and put it up. And the second appraiser came over, and the home was appraised again. And the second appraisal came in at $750,000. So the jump was from $472 up to $750,000, almost a $300,000 difference. And nothing had changed about the home. It didn't jump across the street magically. It didn't, there had been no improvements made. The only thing that had changed was the race of the perceived occupants, right? So like I said, the husband and wife, the couple were both college professors. They knew this was not appropriate. So they ended up hiring an attorney, and they filed a lawsuit in federal court here in Maryland. The lawsuit alleged that there was violations of the Fair Housing Act, Equal Credit Opportunity Act, the Civil Rights Act of 1866, and then Maryland fair housing laws as well. That litigation was filed, I think it was 2021, if I'm not mistaken. And what has happened, I guess just a quick update on that. We're not going to go into all the details, but they did settle with the lender. The lender was named as a defendant, the appraiser and the appraisal management company, all of them were named as defendants, right? The plaintiffs did reach a settlement with the lender. The litigation is still ongoing with respect to the appraiser and the appraisal management company. And then one other really unfortunate update is the wife passed away in the interim. She had cancer and she passed away earlier this year. So I think they had young children, so that's unfortunate. But the litigation is proceeding. I guess we'll continue to monitor that and see how that moves forward. Just that's sort of the Maryland specific case, sort of the high profile case. Just in general, if you guys are interested in appraisal bias, Diamond just showed some slides from the National Fair Housing Alliance. They do a great job. They're really issuing a lot of information, and their CEO is speaking on a lot of panels about appraisal bias. That might be a good source of information if you guys are more interested in this and want to dive into it a little bit deeper. Also, if you are interested in appraisal bias, if you're a video person, you could go on YouTube. HUD has a bunch of videos on appraisal bias. Basically, there's some recognition within the appraisal industry that there's a problem, right? There's all kinds of data and statistics that houses that are in majority minority areas tend to be underappraised and tend to be undervalued. So there's a variety of things that are happening at the national level. I was just going to touch briefly on some of the things that have happened here in the state of Maryland. Like I said, that lawsuit is a big high profile thing. It raised a lot of interest and attention for this issue. There in Maryland, appraisers are regulated. It's the Maryland Commission of Real Estate Appraisers, Appraisal Management Companies, and Home Inspectors. And they had started to look back, I think it was 2022, they started to look into bias, right? And maybe we need to take some steps to try to reduce or eliminate bias in our industry. So they had talked about fair housing being a required class for, when appraisers are renewing their licenses. Maybe we should add a fair housing requirement, add an appraisal bias or an implicit bias component to the class. That they started to talk about that during their meetings back in 2022. Another thing that was discussed and which actually passed in 2023, in general, the appraisal industry, it tends to be primarily male, primarily men, primarily older men, and primarily white men, to be honest. And that's kind of a nature or a function of how you get into the industry. It's an apprenticeship program, right? So if I wanted to become an appraiser, I would have to find someone who is currently an appraiser, and I would have to serve as an apprentice under them, work with them very closely, learn how to appraise homes through them. So I think that's great if you have a family member who's an appraiser. I think that's a lot of times how it works. Your father will bring you into the business. It's not so great if you don't have those connections and you want to get into the business. So that was one of the things that's been discussed at the national level, and also here in Maryland. Maryland, it did pass. The PARIA. It's an alternate path to become an appraiser, where you're learning more sort of online and more that format rather than having to do this formal apprenticeship program. So that did pass here in Maryland as well. And again, the hope is that it will increase the diversity of the appraisal industry and make it easier, I guess, for more people to get into that industry. Another thing that happened here in Maryland, we did pass a requirement for appraisers. There's an additional CE requirement that was passed. They now have a requirement to take 3 hours of racial discrimination or implicit bias classes as part of their renewal, before they can renew their license. Where's the number? I want to say the number out loud. As part of their 42 hours required for renewing their license. Yes, I said 42 hours, and that's all I'm going to say about that. Some of us have a lesser requirement than that, so I'm not going to comment anymore on that one. But those are two positive things that happened here in Maryland. And another thing happened just this month here in Maryland as well. Earlier, I think it was April 9th or 10th. The commission that I just referenced, the Maryland Commission of Real Estate Appraisers, Appraisal Management Companies, and Home Inspectors, they entered into a formal memorandum of understanding with the Maryland Commission on Civil Rights. So what this means is if there is a complaint filed against an appraiser here in Maryland, the commission would refer that to the Maryland Commission on Civil Rights, and they do civil rights all day, every day. They conduct investigations and engage in enforcement action. So the memorandum of understanding that was signed earlier this month would give the appraisal commission the ability to refer those matters directly to the Maryland Commission on Civil Rights, and they would have the authority that they have, to investigate and to issue a decision and enforce any kind of disciplinary action on that as well. So those are all positive things that have happened here on the state level. That's all I was going to talk about appraisal bias, really. I think, what's the next slide, Diamond? Oh, me, okay. AI and fair housing. This is another one that you guys have probably heard a lot about recently. AI, I think, again, I can kind of talk about it sort of at two levels, or sort of a big picture and a more localized picture, or more specific to you and your day-to-day business kind of aspect to it. At the big picture, I think there is some increasing recognition that AI isn't just the answer, right? I think when people started using the internet more, remember people say, oh, everything you read on the internet is true, right? Well, everything that's generated by AI is not necessarily true, and there's some growing recognition for that, and growing recognition for the need to maybe have some safeguards in place and some parameters in place. Appraisals is one issue, one area. Lending is another area where there's some, national recognition that as AI is being utilized more and more in the lending process and the appraisal process, there are some issues that are still there, and we're becoming more aware of those issues. I have a statement I think here from the Consumer Financial Protection Bureau just talking about appraisals. They were talking about AVMs, automated valuation methods, thinking that this might be a way, if it's automated by a computer, then that's going to take that human aspect of it. That's going to take that bias out of it. And of course, it's never that simple, right? The CFPB's guidance, I was just going to read one, kind of skim this or read one paragraph out loud to you. The AVMs can be used as a check on a human appraiser or in place of an appraisal, unlike an appraisal or broker price opinion, where an individual person looks at the property and assesses the compatibility of other sales. Automated valuations rely on mathematical formulas and number crunching, right? So presumably more fair. But this is the key paragraph here. While machine crunching numbers might seem capable of taking human bias out of the equation, they can't. Based on the data they are fed and the algorithms they use, automated models can embed the very human bias that they are meant to correct. And the design and development of the models and algorithms can reflect the biases and blind spots of the developers. Indeed, automated valuation models can make bias harder to eradicate because of the algorithms. The algorithms used cloak the bias inputs and design in a false mantle of objectivity. And that's basically, it's sort of a perception that this was computer generated. It couldn't possibly have any bias. And there now is growing recognition that that's not true at all. And like I said, a few examples, appraisals, of course, lending decisions as well. A lot of lenders, there's been some cases and lawsuits. I guess lenders are using AI to help them make decisions on whether to approve a loan for someone. And a lot of that is based on, credit scores and other information. There are federal laws in place that protect people. And I think what's becoming clear is some of these lenders are making decisions using AI, and they're not able to really document how that decision was made. And of course, if you can't document how your decision was made, then you're going to be violating federal laws. So AI hasn't been quite the perfect solution, I think, that everybody was thinking it would be. For us, for us in our day-to-day business, you probably are seeing, or probably most of you are already using AI in one fashion or another. A lot of the tools that are used on a day-to-day basis are already incorporating AI into it. You may be using it for your marketing, having AI assist you in creating marketing materials or marketing content. I think Central Lock, some of the showing services, they've used AI and it's easier. They've got, a mapping function and a lot of things that just, do make, business easier. Chatbots, you might be using chatbots to answer questions or, respond on your website, or maybe your company has that. I think the key, though, we have to all be mindful of, for one, it's just general risk management, right? Or you being competent in your profession. You can't rely just on the AI, obviously. If I'm going to prepare a listing for a home and I'm going to ask, Chat GPT or some AI program to do that, I can't just upload that and assume that we're good to go. I can't ask my assistant to just upload it and assume we're good to go. These AI platforms and apps, they make mistakes. And again, you probably have heard some cases or read some headlines about some of these things. One that kind of jumps out off the top of my head. There was one, it was a chat bot, I think, with this is not real estate related at all, but I just remember this one because it was bad. Someone who had an eating disorder, and she was doing a chat bot to kind of help her, I guess, with her eating disorder. And the chat bot was giving her diet advice, telling her how to diet, which is obviously not what someone who has an eating disorder, that's not what she was reaching out to that company for. I think, Diamond, we had talked before, I think there was an attorney used some Chat GPT or some AI to help them write a brief that was filed with a court, and it generated cases that were completely fabricated. The cases did not exist, and the lawyer was very sloppy and didn't verify their work or even go back and review it, and they were reprimanded by the judge because those cases were absolute fiction. The cases didn't even exist. So you really do have to be careful if you're using AI. Again, in leasing, I think a lot of these leasing companies or larger companies use AI in making their rental decisions and whether someone's going to be approved for the rental or denied for the rental. You have to be careful about that, of course. There may be a some of these chat bots. Again, you have to be careful if the chat bot is kind of guiding people to a certain community or away from this community and to another community. We all know what that is. That's steering, right? It may be steering versus a chat bot, but that is still steering. That still violates fair housing. That is still impermissible, and your license could be on the hook for that. It could be a claim filed against you or a lawsuit filed against you. So that's not something you can just sort of assume that's going to work properly and just let that ride either. You have to be really careful. You have to monitor if you're using a chat bot or whatever content is being created. Obviously review it carefully, and the laws, like I said, the laws don't go away just because this was created by a computer or AI generated. You still have to review it to make sure there's nothing in there that's discriminatory or would violate the fair housing laws or put you in trouble. Another issue that comes up sometimes with AI, confidentiality. This affects attorneys as well. All of us, if you are inputting information into any kind of platform or app, be mindful. How these AI things, how most of them learn is by the inputs that they receive, and then they analyze it and they'll use that information to generate, better outputs, I guess, with additional questions. Be careful. You should not be inputting confidential information about your clients. You should not be asking them to input confidential information about themselves into any kind of chat bot that you might have, because the AI platform is probably going to use that information to help it improve. So again, you'd have to be careful with confidentiality. That's a concern as well. And finally, I guess the last thing I wanted to say is AI, you have to be careful too. You can't expect that AI is going to just automatically have the updated information and the right information. For example, just what Taylor spoke about earlier. Here we have a new protected class in Maryland. I'm not sure if you used AI right now to ask what the protected classes are in Maryland. I'm not sure that the AI would, whatever app you're using would know that. It's possible they would. It's possible they wouldn't. So again, it's no defense for any of us to say, oh, I didn't create that. I used an app to create that. That's not a defense. You would still be on the hook. So I just, again, be cautious about that. I think the bottom line is be careful, review everything that you create. Review any kind of chat bots that you're using. Be careful they're answering appropriately. If they're not, of course, take immediate action to correct it. Respond to the person, address it however you can. Probably talk to your broker before doing so. And again, any of the brokers or larger companies, if you're thinking about adopting AI and incorporating it into your everyday business practices, talk to the developer and just make sure that you understand what they're using, what data they're using, how they're developing this product. And to the extent possible, you want to make sure that you are trying to eliminate any biases or discrimination that might be baked into it. And at least if you go through the process of asking those questions and interviewing your developers along those lines, I mean, again, it may not be perfect, but at least you'll have a paper trail showing that you were aware of those issues, you did your due diligence. That might be some help in the event that there's a lawsuit or a problem down the road. And that's really all I was going to talk about. That's kind of a quick overview, but I guess we can go forward to the next slide.
Yeah, before we move on, I just wanted to say you are right. I know GPT, sorry. Their free version, I'm almost positive, only has information up to at some point in 2023.
Oh.
So if you pay for the paid version, I think it is up-to-date information, but the free version that I'm assuming most people use, that I use every now and then, it only goes to 2023.
Okay. Thanks, Taylor.
I was going to say too, to just add in, I know for myself, so a little tip for everyone else is AI is wonderful, but it needs a human touch. So like Kathleen said, review it after it, follow up after it before it's released to the public, so to speak.
Yeah. Even listing descriptions. One presentation that I saw, something even as straightforward as a listing description. The AI generated description talked about how wonderful the deck was on the back of the house, and there was no deck on the back of the house. So really, it's a helpful, I would say it's a good first draft. It should absolutely not be your final draft. You definitely need As Taylor said, you might need updated information, or as Diamond said, definitely the human touch to review it and revise it as necessary.
Okay, so moving us into source of income and delving into what those statistics were that we saw earlier, we're going to discuss housing choice vouchers, which make up a good portion of those complaints. So going into a little overview, I'll touch on the recent case, the definitions, like I said, and then landlord and tenant transactions and how you know when to ask your client whether you're representing the landlord, what that looks like, as far as source of income discrimination, protecting them from that. And then also if you're representing the buyer or the tenant voucher, the tenant voucher holder, what that looks like for them as well, and resources. So in December of 2022, there was a lawsuit in DC against the realtor company, and they received a $10 million settlement in the lawsuit against landlords who discriminated against renters with housing vouchers. And this was the largest civil penalty for housing discrimination in U.S. history. And I mentioned earlier that a lot of complaints followed, but the companies here were cited for running ads with illegal discriminatory language, and they were found liable for actively engaging in discriminatory practices to keep voucher holders from applying for apartments, which included charging them higher fees or extra fees just for applicants who were voucher recipients. And as we know, through discussions, that's discriminatory practices. If you're singling out one group in a certain way and putting certain restrictions in their application, you're likely doing something discriminatory. So let's look into what that is, delving into that. So complaints that we looked at on that chart, the rental market shows that we have 27,336 complaints. And this is statistically, this is primarily the fact is that rental transactions are the most frequent type of housing. So that's why it speaks to the rental market, why that can account for 82% of the complaints. And as I mentioned earlier, there has been an uptick in rental-related complaints reported in 2022, as opposed to the prior year. It increased by 1,800 cases, 1,835 cases. So when fair housing violations are revealed in the eviction process, the Fair Housing Act provides remedies for harmed tenants as well. That also attributes to that statistic that we showed earlier, as well as appraisal bias. That was a part of that other type of complaint as well. So the definition of source of income. So delving into that, what that means is any lawful source of income paid directly or indirectly to or on behalf of a renter or buyer of housing. This includes financing and loans. Examples of this mean lawful professions, jobs, government, private assistance, including housing assistance, certificates, and vouchers. So basically, how someone is paying for rent is protected. So whether someone's paying through alimony, someone's paying rent with child support payments, or someone's paying rent with a tenant voucher, those are source of income classes that are protected under that. So I'll get into which statute lists this out as well. But anything that is criminal, if someone is paying their rent with criminal activities, that's not covered. So going into which statute this is in. It's Maryland Code Statute, Section 20-705, if you want to have this for your notes. So this is laid out in a plain way so that you know what a person may not do. So someone cannot refuse to sell or rent after making a bona fide offer to someone because of their source of income. They can't discriminate against any persons and the terms, conditions, or privileges allotted because of someone's source of income. You can't make, print, or publish, or cause to be made, print, or published, or advertise the attention or limit the applicants because of someone's source of income. So no language such as, no tenant vouchers, no Section 8 holders, that is publicizing a source of income discrimination. So you can't misrepresent that your property is unavailable because of someone's source of income. And then finally, you can't induce someone to join into a contract or rent a certain thing because of their source of income. So those are all the categories of what source of income discrimination is. Delving into that, so last week, Kathleen and I actually attended a fair housing forum put on by the Maryland Commission on Civil Rights. And there was a handout that they sent. And in this is a nice little bite-sized way to take in source of income discrimination. So one, can landlords discriminate against people with housing vouchers in Maryland? No, they also can't do so in DC, Virginia. So source of income is a protected class in DC, Maryland, and Virginia. So what that means is it's illegal for a landlord to discriminate against you based on your source of income, which refers to how you pay your rent. What does illegal discrimination toward voucher holders look like? So some examples, like I gave earlier, broadcasting that we don't rent to no Section 8 housing, or we don't rent to tenant vouchers. So a landlord tells you that they won't accept vouchers, advertisements that state no Section 8. A landlord charges a higher rent or a security deposit because you pay with a voucher. Another discriminatory act that I've heard on the hotline, just questions about what is source of income. And one of those questions has been, well, can I have restrictions on, can I look at the criminal history of a tenant voucher? And that would be discriminatory if it's only for that tenant. So if that's a requirement that the landlord has for all of their tenants, then it's not discriminatory. But if you're only putting that limit onto someone with a tenant, or excuse me, with a housing voucher, then you are discriminating, and that is an illegal act to single them out in that way. Going further, can landlords apply minimum income requirements to voucher holders? Yes, you can. So if you have a housing voucher, a landlord can only require that you meet the income requirement for your portion of rent. So what that looks like in practice, for example, let's say the rent is for $2,000 and the landlord requires to show 3 times the income. So they're asking for $6,000 a month or $72,000 for the year. Someone with a tenant voucher, you want to make sure you're only calculating their portion of the rent. So if it's $2,000 and their housing voucher is for $1,800, then they're accounting for $200. So what you need to look at is 200 times 3. Do they have $600 a month that they can pay, or $7,200 a year that they can pay? Because that's how you calculate correctly. Just holding them accountable for what their portion of that rent is. And I think that's also contributed to some of those complaints, because people have miscalculated and wrongfully rejected someone because they did the wrong calculations, and that could lead to a complaint if you're not doing it correctly. So remember that the tenant vouchers are responsible for just their portion, and when you're calculating the minimum income requirements for that. So the laws addressing source of income discrimination and what it says when it's not discrimination. So looking down here at the bottom of this page, the exceptions are found in section 20-704. And here, source of income does not prohibit a person from determining the ability of a potential buyer or renter to pay a purchase price or pay rent. So that's why you're able to have an income requirement and that be okay. So that's a commercially reasonable determination to see if someone can qualify. Then you have source of income does not prevent you from refusing to consider someone who's paying with criminal activity, paying rent with criminal activity. Criminal activity is not a protected class. The source of that income is not protected. So you're okay to say no when you know the funds are coming from a criminal activity. And then third, it does not prohibit a person from determining whether or not they can be a potential buyer to repay a mortgage loan. So still, again, looking at the parameters of, do you qualify? That's a legitimate basis to base a decision on. So going into more exceptions of this bill. So when this law does not apply, I've had that question too of, I have someone who owns 3 properties. The source of income, do they fall under that? Are they protected? Do they have to fall under source of income discrimination? Is there anything that are they exempt? I've had that type of question. So to give you an idea of who's exempt from source of income, having to abide by the source of income discrimination as a protected class. So owners of property who do not use a real estate agent or a property manager, they're likely a smaller specific group. So they're not in the business of selling or renting property. And how you can determine if your client is in the business of selling or renting property is how many transactions have they conducted in the past 12 months. If they've conducted at least 3 transactions that have dealt with the rental market, then they are likely in the business of selling or renting property, and they are subject to source of income discrimination laws. Going a little bit further into that, I'm going to skip around. Factors to help you narrow that down to whether or not is the owner exempt from the Maryland law. So there's 3 questions you want to ask your client if you're the landlord, and this is 3 questions if you're representing the tenant. So is the owner deemed to be in the business of selling and renting property, 3 or more transactions in the last 12 months? If not, then the owner may be exempt. But if so, they have to abide by this law. Is the owner working with someone in the business, i.e. do they have a property manager? Are you the realtor calling in about it? If you're the realtor calling in about it, they're not exempt. They have you. Does the owner live in the property, which is being rented? And does the property have 5 or fewer units? So if they live in that property and there's less than 5 units, they may be exempt from this type of law. So those are the 3 factors that are probably the easiest to use in practice when determining whether or not someone's exempt from source of income discrimination laws. Going into vouchers, landlord and tenant transactions with housing vouchers. So does this mean that every voucher tenant must be accepted? And the short answer there is that it depends. So factors to consider, like I mentioned, can the tenant afford the advertised rent? Will their income and voucher cover the entire rental payment? So in that example I gave, I said $2,000. Well, what if you got a voucher holder who has a $1,500 voucher and they can only give $200 to that? So that means their income for rent is $1,700. Your requirement is $2,000. So no, they don't meet that level. And it is okay to reject because you're looking at a legitimate reason, a legitimate factor as to why that applicant is denied. Is the tenant's creditworthiness sufficient as determined by commercially reasonable and non-discriminatory methods? Emphasis on non-discriminatory methods, because if you're only requiring credit checks for tenant vouchers, you're discriminating, unless that's something that you're applying across the board for all applicants. So that's a commercially reasonable way to say yes to this person and no to this person. So those are the ways that you can stay within that parameter and definitely not be another test subject. As we see, 27,000, 28,000 complaints is a major jump, but that is also a national number. So it's not just here in Maryland. It's an overall number from all of the states there and the agencies that accommodate fair housing issues. So this is the best way, I would say, to navigate that world. Again, the statute that tells you what source of income is not is in section 20-704. And then that's what's considered non-discriminatory. And then you have what is source of income discrimination in sections 20-705. So that's for your notes there. And that's all I had on that.
Hey, Diamond, I just wanted to mention one thing, and correct me if I've got these numbers wrong, but the DC case that Diamond was referencing, everyone references that one because it was bad. It was very bad. I believe the property management company, I believe they had to settle. I think they paid $10 million as their settlement. And one of the owners of the property management company was a real estate licensee, and they had to surrender their real estate license. And I believe, I believe they had promised they would never engage in real estate brokerage services again in the District of Columbia. So don't, brush this off or think, oh, this is just a cost of doing business. Things are going to happen. This is serious. This is real, and you have to take it seriously. Like I said, that was a $10 million settlement, and someone lost their license. So it's real.
That is that case. They did lose their license. Yep. And also what they were advertising and putting through messaging, it was extensive. So they are the premier case to pivot to and say, don't do that.
So. That's what it was. There were internal emails saying, like, we got to find a way to reject this applicant. And, we got to, it was bad. It was bad. So let's not let that happen here in Maryland. Are we finished? We want to go through some questions now? We got a little bit of time left.
We can answer the questions that are in the chat.
Sure. Yeah, I wanted to touch on, well, first, one of the common questions that I saw in the chat was, can I charge an additional pet deposit for a service animal or an emotional support animal? The answer to that is no.
Nope.
Service animals or emotional support animals are not considered pets. Therefore, you cannot charge a pet deposit for the assistance animal. You also can't do things like, charge higher rent, charge a higher security deposit for somebody who's using an assistance animal. You can't penalize the person just because they are having an assistance animal on the property. The second thing I forgot to mention was we have people have sent us reports of websites where you go on the website and it's basically built so people can get around pet fees. Where you go on the website and it says, you know, answer this 10-question survey. At the end, we'll charge you $5, $10, whatever. We'll give you a certificate that says this, you have an assistance animal, and you can provide that to your landlord, and that's legitimate. HUD has come out and said, no, sites like that are not legitimate. The person has to have some connection, as an example, some connection to their healthcare provider who knows them. It's not just a 10-question survey that they're filling out.
I saw a question. It says, how is this best explained to landlord when 100% is paid? I think that's for the housing voucher they're discussing. And when that is guaranteed money, I think we always emphasize explaining that to landlords that this is guaranteed money. I know, Kathleen, you used an example for COVID where there was guaranteed money there when other people were unable to pay. So a tenant voucher during that time meant that they were still able to pay every month because it was a government check. And so that's something that should be posited to your landlords, just so they know what the benefits are, that this is something you don't have to worry about late payments. You don't have to worry about, typically they're longer term tenants. And so sometimes that can absolutely help with even resale value. If they were to sell a property or a unit with tenants in place, that's guaranteed income for the next owner of that property. So that's something to at least inform them about, because a lot of people don't realize that as well. And then I saw, what is that law for income requirement for vouchers? A lot of agents are including the voucher amount into the 3 times, and they have to calculate that correctly. So they can include, like I said, just the portion of the tenant vouchers responsibility into that calculation. And what we'll do is make sure that you have the handout that was provided at the Equal Rights Center after this call, so you can see it, the examples of it and the guidance that came from the Maryland Commission on Civil Rights on how to calculate correctly.
Right. What the misunderstanding, it's pretty common, is that, you know, you can ask a voucher applicant, you know, do you have, the landlord requires that you have income 3 times a monthly rent. Do you have that? And the assumption that a lot of people have is 3 times the, you know, the example Diamond used, $2,000 a month. Well, if you think about it, these are low income, these are vouchers for people with low income. If that were the way it worked, then there would be, no one would ever have to rent to somebody with low income, because just by the definition of being low income and being eligible for these vouchers, no one would ever have 3 times the monthly rent. So that can't work. So if that's what you're thinking, or if that's what your landlord's thinking, get that out of your head. It's 3 times the tenant's requirement, 3 times the tenant's portion, or whatever the landlord's rule is, 4 times, whatever the landlord's rule is, but that would only apply to the tenant's portion, not to the portion that's being paid by the government under the voucher.
I saw a question, I think this is for you too, Taylor. If I have a listing and receive multiple offers and the seller chooses an offer other than an offer with the VA loan, will that be considered discrimination? Oh, that may be for all of us.
That could be for all of us. I think the seller, as long as the listing agent isn't saying don't take that, it's a VA offer, or don't take it, there's going to be all these, you know, stringent requirements, that's problematic, that's discriminatory. But the listing agent can certainly explain the terms of each of the different offers, and if the landlord chooses one that is not the VA offer, that's fine, as long as the landlord is choosing it for non-discriminatory reasons. So that it's
Right.
not, they don't have to accept a VA offer, but they can't reject it just because it is a VA offer, if that makes sense.
There was a very similar questions in regard to vouchers. One applicant is using a voucher, the other applicant is not, and they choose the applicant who's not using the voucher. Is that discrimination? It's not going to be discrimination unless that landlord or the agent working with the landlord specifically chose not to choose the voucher applicant because they were using a voucher.
Right. All right. Well, there's a bunch of questions asking for if they're going to get copies of the slides. Yes, you'll get copies of the slides. If I think Kelly sends those out to everybody pretty much after every webinar that we do. And the webinars are recorded and posted on our YouTube channel as well, within a couple days usually.
Okay, someone asked if MPG a voucher doesn't cover utilities if they are not included in the rent amount. If the applicant doesn't have any income because rent is paid in full with the voucher, how would they pay the utilities and other things? That's going too far into how they're paying, how they're probably paying utilities. Am I correct there? If I'm understanding the question,
Yeah.
you're asking, how are they going to pay utilities in addition to the rent?
Yeah.
And that is not a determination on whether or not they qualify for the unit, I think.
And also the agency that issues the vouchers, they can also cover utilities as well. So that may not even be an issue.
Mhm. Is it okay to refer interested voucher recipients to the HUD website to view properties? Yes, where the landlord is a registered participant. Yes, that may be easiest to for assisting them with homes that you know have had a history with a housing voucher tenant.
Somebody made a good point in the chat about, you know, a voucher applicant can be a great applicant. It's guaranteed money for the landlord. So he's confused as to why people don't like voucher applicants, and I kind of agree with him.
Right. Actually, that Diamond had kind of touched on it. The example that Diamond used, I taught a fair housing class once, and there was a guy in the class, and this was maybe a year or so ago. Probably everybody who's listening, you all have landlord clients who were complaining, oh my gosh, during COVID, the tenants weren't paying rent. We couldn't evict people. There was a moratorium. Baltimore City was two years behind with evictions. Well, this guy in the class had none of those concerns because he had a couple investment properties and all of his tenants were using vouchers. He had not lost one penny during COVID. Every tenant paid on time in full every month. Not one person was delinquent, zero evictions, zero loss of income. So I know everyone has beliefs and the perception, and when, in a class, what people tend to share are the negative experiences. The people who have positive experiences tend to like whisper and come up after class and say, hey, I had an investment property and I had Section 8 tenants and they were great. They were in there for years. They're the best tenants I ever had. So that's just another, talk to your landlord clients, think about it yourself, and where are you getting these ideas? What are you thinking? And then talk to some people, maybe your colleagues or other people who are doing property management. The reality may be far different than what you're thinking. The rent is essentially guaranteed. There are ways, I think, where utilities can be included in that as well. So honestly, in many ways, at least financially, they could be stronger applicants than a typical applicant in many ways.
See a lot of great questions. Do we have time to?
We're right at 2 o'clock.
Yeah,
Want to do
we're
a couple
over
more?
2.
Can Maryland realtors try and get Bright to remove the acceptable financing field for properties in Maryland? It's an optional field, but it is asking for people to commit a fair housing violation.
Yeah, that's a good question. I think Bright MLS is a little busy right now. I'm not sure that now might be the time to ask that, but it's a good point. If everybody's not familiar with what the question is asking, remember source of income also includes the loan type that a buyer may be using. So here in Maryland, if you're saying that, that the seller will only accept cash or conventional, or then you're saying that the seller will not accept VA or FHA, which of course is discrimination on the basis of source of income here in Maryland. So the question is whether we could ask Bright to eliminate those fields, basically to help everybody here in Maryland to make sure that none of us inadvertently violate the fair housing laws. We could ask them. I don't know. All I know is that in other states, source of income is defined differently. Some other states within the Bright MLS footprint. So I guess that would be their IT issue, whether it's possible for them to do that based on whether the property is in Maryland or not. But yeah, we could certainly ask. Happy to ask.
We know
I
it's
can't
not.
guarantee results, but we're happy to ask.
I was going to say it's not a federally protected class, so that is we can ask. Yeah.
All right, let's do one more, and then I think we better get off.
I saw an interesting question. Does discrimination due to disability, i.e. recovery from drugs or alcohol, apply when a company wants to rent the home and have residents with this disability? So I guess they're saying the tenant is a company, but the company's going to have people with disabilities, recovered drug addicts in the property. And whether or not it would be discrimination to deny the lease to that company.
I think that's a little bit trickier. I think it might depend. I mean, if it's basically going to be a group home, I think is what it sounds like, or that's the way
Yeah,
I'm interpreting
it
that.
sounds like that.
That may not even be permissible in that neighborhood or that community because of zoning issues. I don't think that's as easy to just say yes or no. I think you're going to hate me. We're going to end on this lawyerly. It depends. But I think it does depend on where the home is located, and how the facility is going to be operated.
Okay, and then for the questions that we did not get to, we are on the legal hotline. This is the three of us. If you've ever called in, you're speaking to one of us, or if you've ever typed in, it's one of us answering. So we are available Monday, Wednesday, and Friday, 10 to 12 and 2 to 4. So if your question went unanswered, please feel free to go on our website and shoot that over, and we will get back to you through that.
Okay. I think that's it. All right. Thank you everybody for listening. Like we said, this session is being recorded and Kelly will post it on our YouTube channel. She's pretty quick about that. I'm not going to promise anything, Kelly, but generally that's done within the next
Hopefully
day.
tomorrow,
It'll be
Kathleen.
tomorrow.
Hopefully
That's what I was
tomorrow.
going to say. But yeah, she's usually gets it done within 24 hours. And you can have a copy of the slides as well. And again, as Diamond had said, any additional questions, feel free to call the legal hotline. 443-716-3502, Mondays, Wednesdays, Fridays, 10 to noon, 2 to 4, or go on our website. You can submit your questions online, and our assistant Lalika will divide them up among us the following business day. So thank you guys for attending, and enjoy the rest of your day.
Bye, guys.
Bye.